I can speak not to data, but anecdotally. I've been with a group of people for the last 2 years who we've been going into the level 4 maximum security prison yards and teaching workshops on the youth offender parole process, which was referenced earlier. And I guess I can say on a personal level, I have been schooled on what hope is and what hope does for people. And every single prison we have gone into, the wardens have told us afterwards that the prisoners are behaving differently, that they're asking to be into programs, that they're we have inmates who choose to leave gang life, that the presence of hope itself is a motivating factor. And that's part of what this initiative is about, is giving people the understanding that if they work hard, they will have a real opportunity.
Thank you. Did you want to add to that? Or thank you. Yeah, so just a final question. I expect we'll hear from opponents that if you create early parole opportunities for people who have committed and been convicted of felonies, that it's somehow it minimizes the impact of their crimes on victims. I think you've eloquently addressed a unique but important perspective about the rehabilitation process, not just for inmates, but also for victims. But in anticipation of those who will oppose this measure, arguing that it somehow would be a disservice to victims to allow for, I think it will be termed as early release, although my reading is nothing is automatic. It creates an opportunity for earlier parole review, but it is not an automatic. Nothing in this proposal, as I understand it, establishes an early release program. It establishes criteria for parole consideration. But how would any of you respond to those concerns of those representing victims, community?
Yeah, if I could just speak to the victim side of it. Like you said, and thank you for saying it, this does not provide any type of early release. It is simply an opportunity for a hearing. And obviously, it's the parole board who decides who is fit. Now, what I am interested in as a victim is somebody coming home who understands the underlying reasons that they committed the crimes that they committed, that they have had the opportunity to understand the impact of that crime, that they have had the opportunity to build empathy for crime victims, and whether or not they are serving their entire sentence, we already do that. First of all, we already release people early. We've had to, right? We already do that. But what we don't do is ensure that they're ready to come back into society in a productive and fruitful way. We set up barriers to their successful reentry. It seems every opportunity we get, we're just throwing up barrier after barrier, and it sets them up for failure. And what that does ultimately is create more victims. And so what I'm really interested, the conversation I really want to have, and I really want all of us to start having, and we are to a certain extent, but it needs to grow, is how are we going to get people back home who come home and are like Frankie? How do we do that more? Right? And so I'm less interested in giving, and less concerned about giving people the opportunity for a hearing, and I'm more interested in in setting them up for success when they come home. And we can do that through these programs. Thank you.
Any other?
Yeah, I mean, I would just like to point out that in California, and like in many other states, we have a big problem where we send far too many people to prison for far too many years. And it's become unworkable. It's creating a public safety hazard. And we have a process by which prosecutors prosecute, judges should judge and sentence, and the CDCR should rehabilitate. But because of sentencing enhancements, mandatory minimums, judges are often forced to impose very lengthy sentences. And so when we say, or when the opponents say, that we are undoing that which a judge has done, it is untrue, for lack of a nicer term. And so what we are trying to do here is essentially create a process that makes sense, as we've identified, one by which a prisoner would earn his release. There's nothing arbitrary about this. We are empowering people that are in the best position to understand who is and who is not rehabilitated to earn good time credits. And so otherwise, our process is arbitrary. We are sentencing a person to an indeterminate term of years at the outset, with no expectation of having this person come home, but they do come home far worse, and that is not public safety. And so really what we're offering here is a process that makes sense, that ensures people will do the work and earn their way home.
Thank you very much. Thank you, Mr. Chair.
You're welcome. Mr. Leno.
Thank you, Mr. Chairman. I'm sorry I missed some of the presentation. I had to go to another committee to cast some votes, but I want to express my appreciation, first and foremost, to the governor and all the other proponents who are before us today for taking on the very challenging task of taking a clear look at what the status quo is, recognizing that it's not the best we can be doing for the state of California, with the goal always being of greater public safety and lowering our recidivism rate. And I've often thought that even using the term recidivism rate is not speaking clearly to what we're talking about. It should be a re-victimization rate. For every time someone recidivates, there's another victim. And recidivism is a little too clinical. And to say we have the highest recidivism rate in the state doesn't really address the fact that we have more victims than we need to have. But upsetting the status quo is a challenging thing. There are a lot of entrenched interests. And so if we can recognize we can do better, then the real question is how. And from a historical perspective, I think it's fascinating that the governor who put in place one system so many years later recognizes, as he said himself, every reform needs a reform. And so this is a reform effort. When I was a freshman assembly member and sitting in Chairman Joan Sawyer's seat as chair of the Assembly Public Safety Committee, we did a little research and determined that in 2003, the state of California was spending 5.3% of its general fund budget on the Department of Corrections and Rehabilitation. At that time, Department of Corrections. Rehabilitation was too controversial a term for us even to put into the title of the department, or even to have it in the definition of incarceration in our preamble to the California Penal Code. 5.3% of general fund. It was the highest percentage of any state in the country. 14 years later, we're closer to 11%. And the question is, and if it weren't for some of the reforms that Governor Brown has put in place these past number of years, we would be higher than 11%. And at what percentage do we say enough is enough? And what are we getting for these billions and billions of dollars when we know earlier investments on the front end, as you pointed out, Mr. Guzman, goes a far ways longer than coming back at the back end and trying to do something about it then. I'm also reminded, because I know we'll hear from those who have a difference of opinion on the initiative, of how dangerous to the public some of these offenders are. And I'm reminded of a comment that Brian Stevenson of the Equal Justice Initiative has said, that all of us, we are all more than the worst thing that we have ever done. And I think that speaks to the very fact that not only is that statement true, but it's incumbent upon us to invest in the rehabilitation. And with regard to the juvenile aspect of this initiative, Mr. Guzman, your testimony was very powerful, and not only does your own life experience put a face on this conversation, but I hadn't myself such as clear an understanding as I do now of what the direct filing does and the disproportionate use of it. So there's no fairness or justice in the status quo here. No one could argue that there is. And that the judicial discretion will allow for a more transparent consideration, and I think bring a greater balance back. And then, of course, what is our eagerness to put these youth in the adult system, especially when we know now that we have added rehabilitation, at least in name, if not in fact, and Senator Hancock, of course, has led the charge for so many years to make sure we have more rehabilitation in our adult system. But the adult system is not about education. And maybe we have a little more rehabilitation today, and we might have it by name, but not in fact or investment. But that is specifically what the juvenile system is about. It's our charge, our statutory charge, to make sure, whether we're doing a good job of it or not is another conversation, but to keep youth in a juvenile system rather than an adult system means they've got at least a prayer and a greater chance of getting that education and getting that rehabilitation as you did. And isn't that really what we're supposed to be doing with our youth? And we've been working also on making sure that room confinement is contained, and that we don't subject our most troubled youth to the most damaging practices of our system. So there are a lot of other ancillary issues that we need to focus on as well. But I think your testimony today has been very helpful. And I know we'll have a lot of questions for those who have presentations in the next panel. But I think as this conversation continues through November, we need to focus on, as Ms. Calvin mentioned in your opening statements, that this is about building bridges to rehabilitation. It's about the possibilities of and the necessity for rehabilitation. So thank you.
Thank you.
Thank you. Are there any other?
I have just a quick.
Ms. Hancock.
Yeah, I have just a quick factual question. I appreciate the comments, and I'm very grateful for the information that we've gotten today. But as we look at this, the statement's been made that the majority of inmates in our state prisons are determinately sentenced. Do any of you know what that percentage actually is, or does the LAO? People who will be returning, and we do want them to return as safe neighbors and better than they came in.
So I believe that the number of indeterminately sentenced inmates is right around 34,000. The state's total prison population is north of 120,000, and the balance are determinately sentenced.
Please, can you
So that's about
do the math for me right now?
let's see here, about I think, what would that be? I think about 3/4 are determinately sentenced.
Thank you.
Okay. Thank you. Are there any other questions? Yeah. I just have one, and it's really about this research on juvenile brain development. I know Mr. Guzman is here, and how it fits with the juvenile policy here. You know, I remember watching a movie called The Bad Seed where the little girl just about killed everybody, the mom, dad, the handyman. And this is really kind of directed toward Ms. Butler, who actually works, her members actually work with juveniles. And it is this notion, not only that we want vengeance, we want to punish, but is there a thing of there's no child that you can't turn around? There's no matter how heinous the crime, does every youth have an opportunity to turn their life around, especially if some of the research has shown that developmentally their brains have not developed to a point where I'm not going to say they don't know what they're doing, but they may not have full adult understanding of what they're doing.
Right. Current brain development really says that the adolescent brain is still developing through 21, and some researchers will now say through age 25. What we see in the juvenile facilities is every youth has the ability to improve their thinking, improve their behavior. I wish I could say we could rehabilitate every single youth. I can't say that. There are some that make choices that, even given the best services, but you don't know who that youth is. So you have to offer those rehabilitative services to all youth, because the ones that you might cross off and say that's the one that will never make it could surprise you and be the one that actually absorbs what they're being taught and can make that change in their life, overcome the trauma that they've had in their early childhood. I can't tell you the high percentage of youth that come into this system that have some sort of trauma. It's very, very high. And without looking at those issues and looking at their mental health issues, substance abuse issues, all of that component together, we have to offer those services, and we can be effective with many, but not, there will always be some that we just can't do it. But we shouldn't not try. And I think that's the philosophy of all of the juvenile halls, is that no matter who's in our facility, our goal is to try and rehabilitate them regardless of where they're going to go. Even those youth that are in pending adult court and that are likely to go to prison, we still offer those rehabilitative services.
And on that point, you also make sure that you don't let anyone out that shouldn't get out too. And I think that should be noted, that I wouldn't call parole officers or probation officers soft on crime, and that you take the job.
No, accountability is a huge piece of what we do. Okay. And without those two together, it doesn't work. It really is that joint effort of accountability and rehabilitation. You can't just do one or the other.
Thank you. You want to say something, Mr. Guzman?
Yeah, I just wanted to point out that when we talk about brain development, and especially with young men, young men continue to grow into their mid-20s. I can tell you for myself, I didn't grow up and start thinking like an adult until I was 23 years old. And when we talk about whether juvenile probation can turn a kid around, I think largely it's a function of jurisdiction. Juvenile court ends around 18. Meanwhile, a kid is still growing. I was in the juvenile system, the CYA. Fortunately for me, I continued to get services up until the age of 25. And so I had a parole officer who worked with me and understood that I was just like him at that age, I would imagine. But we also have to account for the fact that what trauma does to a kid, or developmental disability. So you can take an otherwise normal child and judge that person against this timeline. But if you've experienced serious violence, trauma in your early childhood, it's going to take you a little bit longer because it doesn't impact your development. And so when we're talking about turning a kid around, we have to talk about healing, not just educating a person on good decisions, but also healing, dealing with the trauma, and not exacerbating that trauma with whatever we might do in the system. So it's a very complicated system, but one that is best suited, or rather best delivered through the juvenile court. So I just wanted to point that out, that it's more complicated than simply, I would say, I have never met a kid who I couldn't turn around if I had the time and the resources to do that.
Thank you. And I want to thank the panel for being here today. It's been very informative. Thank you. And we'll bring up our next panel. Larry Morse, the second District Attorney, Merced County. Robert Messman, Senior Deputy District Attorney, Orange County. George Hofstetter, President, Association of Los Angeles Deputy Sheriffs, and Mark Kloss, Victims Advocate. Gentlemen, welcome. Welcome.
Assemblyman, nice to see you.
Good to see you. Same rules. We have 30 minutes. You divide it up whatever way you want, and then we'll have question and answers.
Thank you very much. I appreciate the opportunity to be here. I've had conversations with some of you about some of these issues. Interesting listening to the proponents of the initiative. We had two major concerns with it. One, as you know, was the process. We believed that it was the initiative equivalent of a gut and amend, in which another initiative had been introduced, and then late in the process it was essentially cannibalized by the second half of the initiative, which deals with the adult parole process. And we think that the decision, we obviously respect the decision of the Supreme Court. We think it was a dangerous precedent, and that many members are going to come to rue the way this unfolded, because it is going to legitimize the same tactic on things that many members of the legislature may find much more objectionable in the future. Big money people coming in and coming on towards the end of an initiative, the qualification process, and attaching something that is only remotely connected to the original initiative that was introduced. But we will see. The District Attorneys Association was very much split on the original initiative that was introduced, having to do with the juvenile, the decision whether to bring juveniles up to try as adults. I can't speak for all of my colleagues, but I know that many of us would not have opposed, and many of our members would have actually been in support of that provision that would return to judges the decision on whether to bring juveniles up for adults. That was an issue that was much more debatable within our association. What we're really here to focus on, and what our association is almost unanimously opposed to — I think there's maybe one of the 58 DAs who has expressed support for this initiative — is the adult parole aspect of it. In 2011, this legislature approved the governor's realignment proposal. It's important to note that the California District Attorneys Association did not oppose realignment. We were neutral on realignment, and we recognized the pressures that the governor was under with the federal court order to bring down the prison population. And we have worked very diligently across the state with probation departments, with county governments, to implement realignment. And we have noted many successes in the realignment process. On the heels of realignment, however, we had Proposition 47. We were almost unanimously opposed to Proposition 47, making misdemeanors of a host of primarily theft and drug crimes that were previously felonies. What we would note for the members of this committee is that, our overriding interest is in public safety, the safety of each and every community in the state of California. And until the last couple of years, we could point with enormous pride to great success that we had had in the reduction of violent crime in California. Until the last couple of years, violent crime in California had been steadily decreasing. Now, however, in the last couple of years, it has risen, and risen sharply. Property crimes are through the roof. For the first half of 2015, with violent crimes, 5 of the 10 most violent crime increases nationwide were in California. Number 1 on that list is right here in Sacramento. The largest increase in violent crime in the United States was right here in Sacramento. Property crimes, 5 of the 6 largest increases in property crimes in the United States were in California. San Francisco, Senator Leno, has had a nearly 700% increase in property crimes in the last year, for which the statistics were available. Now, others may disagree. The District Attorneys Association believes very strongly that this is a direct correlation with both realignment and even more so with Prop 47. The statistics were released on auto theft in the last couple of days, and auto theft numbers are through the roof. And again, California is leading in an area in which we don't want to lead. We are far and away having the most proportionate number of auto thefts in this country. And police chiefs throughout the state are near unanimous in attributing it to Proposition 47. Now, I say that as a backdrop because now, while we're still reeling and coming to terms with realignment and Prop 47 and trying to understand what the impact has been in our communities, we are faced with a new initiative. We consider it to be somewhat disingenuously entitled the Public Safety and Rehabilitation Act. This is Prop 47 on steroids. Although the initiative claims to release only non-violent offenders, let you be the judges. Tell me, if you would, whether you consider the following crimes to be nonviolent: assault with a deadly weapon, soliciting another to commit murder, supplying, selling, or giving a firearm to a person to commit a gang crime, rape of an unconscious person, sodomy by intoxicating anesthetic or controlled substance, abduction of a minor for purpose of prostitution, human trafficking involving forced labor or sex acts, possessing, manufacturing, or acquiring a weapon of mass destruction, inflicting physical pain on an elder or dependent adult, shooting at an inhabited house, occupied building, or a car by a gang member, using force or violence on a witness because of assistance to law enforcement, inciting a riot in state prison or county jail that results in serious bodily injury. I could go on and on and on. CDA prepared a list, 8 pages long, with crimes of this nature that I believe most of the members of this committee would absolutely consider to be violent crimes, but which under this initiative are nonviolent crimes and thus eligible for the early parole. The governor's own staff admitted in an article, a column by Dan Walters recently, that CDAA is correct in listing these so-called nonviolent crimes as eligible under this initiative. Now, how does it work? Let me give you one very simple example. We have an assault with a deadly weapon. All right, the triad on that is 2, 3, and 4. All right. The person convicted of that has assaulted one person, but it was especially vicious assault. He had a history of minor felony drug offenses for which he had not gone to prison, and misdemeanors. He's given 3 years in state prison. All right? We have another person who's charged with assault with deadly weapon. He's a gang member. The crime was against multiple victims. It was committed for the purposes of the gang. He has a strike for a previous crime involving use of a firearm. And he's been to prison before. So his sentence would be 12 years. Multiple victims, gang member committing the crime for the purposes of the gang with a strike. His sentence would be 12 years. Under the governor's initiative, both this individual and the person in the first hypothetical would be eligible for early release after 3 years. That's a 9-year discount. Prosecutors make this decision each and every day when we are looking at filing cases. We are looking at the instant offense and the person's history. Because frankly, some of these people are repeat offenders, and this initiative does not distinguish their previous criminality, their previous violence, their previous prison history. It makes all of them eligible at the primary term, at the conclusion of the primary term.
Sir, you're at about 10 minutes. I just want to make sure we can hear from everybody.
Incentivizing change, as I heard discussed in this presentation, non-violent inmates, including the ones that we've already listed, all these crimes that we already listed, already get half-time credits. They get 50% credits. This initiative eviscerates the Victims' Bill of Rights and Marsy's Law, both passed by voters, and it makes judges essentially advisory personnel in the handling of cases that come before them. That's on the front end. And now with the credits aspect of this initiative, this is not limited to nonviolent offenders. This applies to everyone in state prison: murderers, robbers, rapists, child molesters. All of them are eligible to have credits above and beyond whatever they're going to earn, the 15% credits. They are eligible to have additional time taken off their sentence by programs we have not had identified and which do not exist presently, created at some future date by the Department of Corrections. And we don't know how many credits can be awarded or the scope of it. So it's a poorly drafted, poorly conceived idea that will make California less safe. Let me give you one more quick stat. In 2011, in 1980, Los Angeles had a homicide rate of 34.2 people per 100,000. 34.2 per 100,000. In 2013, before implementation of realignment, before Props 47, the homicide rate was down to 6.3 per 100,000 people. So in 1980, 34 per 100,000 to 6.3 per 100,000. The Los Angeles PD reported that crime had declined for 10 straight years. That's because we have taken the most dangerous, the most violent, the most repeat offenders off of our streets, and our communities, our families have been safer as a result of it. 11% increase in violent crime in the first 6 months of 2015. This initiative is a disaster for public safety. It will make all of California much less safe.
Thank you.
Go ahead.